Ag Bioscience, the #1 ag tech podcast globally, is now available on video. Hear from leaders and innovators across food, animal health, plant science, ag tech, and agriculture. Mondays at 6 a.m. on YouTube or wherever you get your podcasts. While you're there, subscribe and leave us a review. It's the Ag Bioscience Podcast with Agronovis Indiana. Get more information at agronovisindiana.com.
The internet changed how we work. AI is changing what work gets done. A bank cut loan processing from days to hours. A student built an AI scheduler, improving on-time delivery from under 70% to over 90%. Most teams know AI matters, but aren't sure where to start. InAI is Indiana's statewide AI adoption effort, built with industry, academia, and community partners, helping you move from understanding to action. Visit inaiready.com.
Welcome to the Indiana Lawyer Podcast. I'm your host, Maura Johnson. In today's episode, I sat down for a conversation with Jim Bopp, principal attorney for the Bopp Law Firm and one of this year's Lifetime Achievement Award honorees, to learn more about his career in the law and the experiences that shaped it. Each year, the Indiana Lawyer celebrates a cohort of legal professionals making an impact in their communities and the state during our Leadership and Law event. The event also honors a Lifetime Achievement Award recipient who has at least 25 years of experience and whose professional impact extends beyond the courtroom. In our last episode of the podcast, I spoke with Ken Falk, legal director of the ACLU of Indiana, who was honored alongside Jim Bopp for this year's Lifetime Achievement Award. In today's episode, I'm joined by Bopp to learn more about how he got his start in the profession, his work building a solo practice firm, and the cases that left a mark on his career. You can find his full leadership and law profile on our website at theindianalawyer.com. I hope you enjoy our conversation, but first, let's hear from our sponsor.
Taft, today's modern law firm. At Taft, we cultivate a highly respectful, transparent workplace that fosters creativity, teamwork, inclusion, and diversity. We couple our culture with a client-first approach, rewarding lawyers who understand their clients' goals and work to deliver success. Taft, the modern law firm. To learn more, visit taftlaw.com.
Just to kick things off, can you just kind of walk me through when you decided you wanted to study law? What did that look like for you?
Well, I'd always been interested in government and politics and conservative philosophy since I was really very young man. Actually started reading about it in grade school and through junior high school, at the impetus really of discussions with my father. And by the time I was a sophomore in high school, I really had a pretty well-developed conservative philosophy that I was committed to. So since I organized my high school for Barry Goldwater that year in 1964, that's a little bit of an exaggeration. I did organize 30 kids out of the 1,000. So, but, and my interest continued into college when I went into pre-med. My grandfather, my uncle, and my father all practiced in Terre Haute, all doctors. And I thought I would follow in their footsteps until second semester organic chemistry convinced me that I ought to be a lawyer. And that was my second choice because of my interest in government and politics. And really very thankful that God led me that way rather than what I was trying to pick for myself. I did not have the mind to be a doctor, but hopefully I feel like I've been able to fit in the legal profession.
Yeah, absolutely. You said that you took an interest in just starting in grade school. Was there something specific, like a book you read or something that kind of sparked that interest that early on? Do you remember?
No, the books that I read, which were many, followed discussions with my father at the dining room table. He was very interested in politics. He didn't participate in it much, but he thought about it, had opinions about it, and would talk to me and my 4 younger sisters about it. And I just really took an interest. And but then I thought I would follow up with, is he really right about these things? Is this really the path that I would want to go on? Is this really the best thing for me and the country? And I concluded that it was, and that's and I've never gone back from that decision.
Yeah. So when you got into law school, would you say pretty set on pursuing election law, constitutional law, that path for your career?
I actually haven't figured out quite the path. I just knew the big goal.
Mhm.
The big goal being, however I could do this, I wanted to advance the conservative cause. Now, once I got through law school and my first 2 years was as a deputy attorney general in the Indiana Attorney General's office. I'd already been involved in various political activities in high school and then in undergraduate at IU, both conservative kind of politics, but also student politics. I was president of the student senate at IU, ran for president of the student body, lost. Our campus was a little too liberal by then, by 1969. So I had started to get an idea about how a lawyer could do this, and that is through their practice. One way is to assist conservatives doing things, okay? So not-for-profit tax, assisting conservative organizations, being able to navigate the tax code and being set up in an effective and efficient way. Candidates for political office or PACs or political parties have issues with campaign finance laws and running their campaigns and all that. Representing conservatives or conservative organizations in that way, it became obvious to me a way of becoming involved in helping the conservative cause. And I mean, I got my first national organization in 1978 when I became general counsel for the National Right to Life Committee in Washington, and I still am general counsel for that. But many other conservative groups, both national, state, et cetera, I have represented over the years. But it also gave me an opportunity to get involved in lawsuits.
Mm.
First, helping various conservative organizations with the issues that they are concerned about. So I have filed dozens of amicus curiae briefs, friend of the court's briefs, all over the country, a lot of them in the U.S. Supreme Court, supporting right to life issues. And then a couple of years into representing national right to life, they got whacked by a regulation that the Federal Election Commission adopted that essentially prohibited voter guides. And those are the things that the League of Women Voters have put out since the 50s, where they list the candidates and they say what is their candidate's position on certain issues, support, oppose, reducing taxes, okay? But the Federal Election Commission didn't apparently like the fact that in 1980, for the first time in history, the Right to Life movement did voter guides throughout the United States, millions and millions and millions of voter guides. And of course, Ronald Reagan got elected president. There were 12 incumbent Democrat pro-choice senators that lost to Republican pro-life senators taking over the U.S. Senate. And the FEC decided, hey, we want to regulate those people. And the result was my first campaign finance case, which led to literally hundreds of campaign finance cases challenging state laws, federal laws, IRS rules and regulations for many, many years.
Yeah, that's interesting. And I think something that stood out to me from your leadership and law profile was your emphasis on your experience in debate when you were in high school and college. So I'm just kind of curious, can you talk a little bit more about that and how that contributed to your education and in law school and now in your career?
Well, my first year of high school as a sophomore, I did two big things as far as my extracurricular activities were concerned. One, I went out for the football team, and I made the JV football team as a wide receiver. Hard to believe now, but anyway, he did want to switch me to center, which made more sense, and speech and debate. And we had a very, very active speech and debate program literally every weekend, 25 tournaments a year. Every weekend, we would go to a speech and debate tournament. And I just loved it. And so toward the end of my first year, my sophomore year, I thought, well, geez, I really can't do football on a Friday night and go on a debate tournament on a Saturday all day, get up at 5 a.m. or whatever. And I really felt like I had to choose, and I knew I was not going to be a college football player. My wife is way more athletic than I am, and in fact, my daughters got that from my wife, all varsity athletes in high school and 2 in college. So, I decided to concentrate on speech and debate. I ended my high school career rated as one of the top 10 in speech and debate in the United States.
Oh, wow.
And we had a point system, and I was in the top 10. And then I debated intercollegiately for IU. And it seemed obvious that my interest in politics and government and law, learning how to speak about things, try to persuade people in your speaking, learn how to be a good speaker, made sense. And of course, when I switched to being a lawyer, it really made sense,
Right.
big time. But there was a benefit that I really didn't realize until later on that has one of the most significant things as far as my attitude on life and politics and political philosophy. And that is, it taught me that there are reasonable, good faith arguments on both sides of an issue. Each in debate, you might debate 4 times where you start affirmative, and then the very next debate, you're the negative, and then affirmative, then the negative. And you do that for a whole year.
Yeah.
And you realize, I mean, here I am making arguments. I usually have an opinion on the topic, right? But here I am making the best argument I can that doesn't match my ultimate conclusion about that, my view on it. But I could make reasonable, good faith arguments and not feel like a fool or an evil person or anything. And so you just came to realize that just because somebody disagrees with you, that doesn't make him an evil person. It means just that they disagree with you, and they've come to a different conclusion, and they can do so in good faith and with on a reasonable basis. And you should treat them that way as just somebody who you can be friends with, you can collaborate with. You just happen to disagree on a particular political issue.
Yeah. Do you feel that your ability and your practice in understanding an argument from both sides helps you in your legal practice of being able to best argue for your client on one specific side?
Yes, it really does. To shut off the other side of an argument has 2 detrimental effects. One is you can't understand the other side, all right? And actually, that's 3. The second benefit is that it helps you be a critical thinker, because when you look at both sides of an argument, then you've got to decide which is the one you want to adopt. Well, that's critical thinking skill. If you just shut out one side, how can you learn how to think about things, think about arguments, and how to reconcile or choose them? So and the final benefit is I learned early on that, to my horror and shock, I didn't know everything. So if you listen to other people and their points of view, you will actually find out that they have reasonable things to say that you might actually agree with and adopt.
Yeah.
And that just makes you a much better person and a much better at coming to good conclusions about how things ought to be. And so it's very beneficial to listen to the other side. Quote the other side, end of quote, because at the end of the argument, you might be on that side. You never know.
Yeah. So I know that you obviously are in charge of your own law firm, and you started that early on in your career. What motivated you to go that route and choose that kind of solo law firm?
Well, I have an unconventional practice, right? I mean, the vast majority of law firms are organized to maximize their income. I mean, that's the goal. Now, I'm all for that. I'm a capitalist. There's nothing wrong with that whatsoever. But they have that as their goal. Well, that wasn't my goal. My goal was to advance the conservative cause. And every day I've awakened for the last 60 years, yeah, I think about that, is what can I do today to advance the conservative cause? Now, of course, I have a wife. I have 3 daughters that have been very successful, wonderful children, 8 grandchildren, a lawyer, a nurse, and a teacher, and now mothers raising children. And of course, I had to provide for them then and now and after my passing, probably. So, of course, I had to make a living. But to maximize my opportunities to advance the conservative cause meant a lot of pro bono. I represent groups pro bono, candidates pro bono, various political activities. I was very active, have been very active in the Republican Party. I was a county chairman. I was state party treasurer. I was on the Republican National Committee representing Indiana and vice chairman of the Republican National Committee. Uh, and I brought an enormous amount of pro bono lawsuits over the years. So this doesn't fit in the normal model. To my chagrin, somebody recently told me they're in a big law firm, like 1,000 lawyers all over the country. They're required to do 2,400 billable hours a year. Now that's over 50 billable hours a year, but because there's plenty of things that lawyers have to do, you can't bill for.
Right.
So it's enormously. I mean, you have to work at night and on the weekends. I couldn't possibly be doing the pro bono work that I want to do, that I felt called to do in that environment. So I just had to figure out my own path and try to balance all these so that I could care for my family and while at the same time accomplishing my goal of advancing the conservative cause.
Yeah. How, in developing your firm, and how have you been able to kind of balance that and your pro bono work alongside supporting a family and raising a family? How did you strike that balance?
Well, you got to get a wonderful wife and mother that's ready to take the lead. Because when you represent people all over the United States, I've sued 45 states. I've argued in every circuit court. I've argued in over a dozen state Supreme Courts in cases in their state. I've had cases decided on the merits 14 times in the U.S. Supreme Court. That required a lot of travel. And that's, there was no way around that. Now Zoom has made it easier. It's cut down on the travel quite a bit, thankfully, but that was the big cost. But my wife raised our girls. I'd like to say with my help, raised our girls, and they turned out wonderfully, wonderfully well.
And I know you've said a lot about your mission of. Sorry, I just drew a blank for a second. You talked a lot about your drive to further the conservative cause. How does that goal influence which cases you choose to take on to represent clients in?
Oh, it makes a big difference. When I started my practice, I actually went out after 2 years in the Indiana Attorney General's office with another guy, and we set up our own private law firm, and we had no clients. And of course, at the beginning, we would just take anything that we thought had merit in a lot of different areas of the law. But I was always thinking, okay, I want to advance the conservative cause. I'd like to get clients that I can help do that. Okay. And fortunately, along came Indiana Right to Life. I've become one of my real mentors in life. It was Stan Evans, who was editor of the Indianapolis News at the time.
Yeah.
And he mentored me in college. And then when I came back from University of Florida in my practice, and he referred Indiana Right to Life to me because they needed a lawyer. and the one in Indianapolis where I started my practice. And so, and I was just thrilled to death to do it. And so I started on the path of what I'd already figured out would be the things I would need to do to be of maximum benefit, and that's representing these people. By then, I helped a congressional candidate that same year in '76 with a legal problem, pro bono, and so it just started and blossomed into quite an array of clients over the years, including the Republican National Committee. I won a case in the United States Supreme Court for them. So I've been very blessed that I set out on a road and have actually been able to walk that road.
Mm. Something that sticks out to me is your emphasis on this pro bono work. And I'm just kind of curious because I feel like there is often talk that there's never enough, but can you just kind of talk about the importance of the pro bono work you've done and obviously the importance to the clients, but also to your experience as an attorney?
Well, the way, because the pro bono work, most of it fit and had a symbiotic relationship with what I was offering as a lawyer, which was my legal representation. So I became prominent in first the Vigo County party, and then the state party, and then the national party. And when I started winning cases, campaign finance type cases, then people started coming to me with their problems, or if they, I represented the Christian Coalition in their heyday in the '90s and won the largest FEC investigation and enforcement action in history, and won the case for the Christian Coalition. But so then I started to develop a reputation as somebody that could handle these problems, and that of course kept expanding my opportunities to serve. The other thing that's important that you have to always keep in mind is it isn't very long before, and hopefully not very long before, you've got to cross the threshold of having associates.
Mm.
Because if you just limit yourself to what you have the time and energy to do, you're going to really restrict your opportunities to serve. And so you've got to be prepared, figure out how to attract the associates that you need and be able to fund it, and also be able to know how to manage it. And managing associates is a really important element here. At my maximum, I had 15 associates that worked for me. And you have to learn how to delegate to them, how to trust them, also how to mentor them, to teach them how to, in the way I look at it, practice at the top of the profession is our goal for every associate. I've got to learn how to mentor and teach them so that they will provide maximum benefit to the firm, but also be prepared, as many of them have, go on to other endeavors in the legal profession where they can advance the conservative cause themselves in what they do in their other aspects of legal practice. So it's a combination of things.
Yeah. Something else that stuck out to me in your leadership and law profile was your emphasis on your conversion to Catholicism. And I was just kind of curious, how do you feel like your faith in you impacts your work and your career and your drive to represent your clients?
I grew up a Methodist, attended the church where my mom took me and my 4 younger sisters to church every Sunday. And but once I married my wife, who was Catholic, I started attending Catholic church. But I was called 10 years ago, to 8 or 10 years ago now, to improve my relationship with God, to get a closer relationship. And the way I thought you would do that is you would make the commitment to join a church in which you felt that could blossom. And that's what I decided to take RCIA, and it was a year-long program of learning about the Catholic faith, and then being confirmed in the church. Now, one thing I did learn about that experience also, however, is I have a certain turn of mind, okay? And I am really good at tactics and strategy. I've read an enormous amount of military strategy books because they explain the best explanation of those strategies and tactics that I have found to be perfectly suitable for litigation and politics. It's all the same kind of turn of mind. Philosophy, theology, and God forbid metaphysics, I just completely lost. I have no mind for it. And so that's been a barrier
Yeah.
to me really diving deeply into the Catholic faith, even though I do my best. I understand my limitations also.
Yeah. Do you feel like that drive and that work in your faith has impacted your drive in your work in your career?
I sure hope so. I pray that is the case. It has made clear to me several things, one of which is particularly a problem for lawyers and successful people generally, is pridefulness. And pridefulness is a sin, and it leads you to destruction. And but it can so seduce you. Okay, particularly if you're surrounded by people who spend all their time praising you, which a lot of successful people, that's one of the problems. When they need candid and truthful advice, and they're getting BS praise from the people that ought to be actually helping you by telling you the truth. It's something that is a danger for human beings, and it is we really have to be cognizant of it because it is very destructive and leads to very destructive behavior that you would not otherwise engage in except because you've taken that path of pridefulness. So that would be an example of something I believe I've learned that I hope I am very conscious of, because you have to be, and follow that path.
Right. Yeah. I know that you've emphasized this from your perspective, a lack of civility in the courtroom these days. Can you kind of talk about that perspective and how you try to kind of counteract that in the work that you do in the courtrooms and how you represent clients?
Yeah, it's not just in the courtrooms. I mean, it's an argument, but it's more prevalent actually in writing, in pleadings, and that is the willingness, and it seems to be almost ubiquitous, at least in my practice. And when you've had lawsuits in 45 states, you're practicing against lawyers in the bars of all these states, and in many instances, the top lawyers in those states. And the amount and that focuses on ad hominem attacks on the opposing counsel and the opposing party, but a lot of times the opposing counsel, where they're always questioning your integrity, whether you have good, that you would be alleging you have bad motives. And to give you an example, you have a disagreement on what a case stands for. All right, we look at it and we say, well, we think this is what it stands for. They look at it and say, no, it stands for something else. When they critique what I'm saying, they say I'm, quote, misrepresent, end of quote, the holding of the case. Well, see, misrepresent is a word that means I know it doesn't mean this, but I'm lying about what it means. Okay? That's misrepresentation. Well, see, that's an ad hominem attack on a person's integrity, right? Rather than saying misstates. See, misstates goes to what you're saying, not what your motive or your thought processes or your intention is. And so it's dealing with the argument, not the person. Right? I mean, I don't see any reason ever to say who the other lawyer is. Because a lawyer is just speaking for a party. These are between parties, not between lawyers. Okay. So the way we deal with this is, one, we don't talk about other lawyers. We only, an argument is being made by an opposing counsel, by an opposing party, not the counsel. He's representing the party. And we never engage in ad hominem attacks. We would never use the word misrepresent. We would say mistake. Now, we do, however, are willing to expose what they are doing, all right? But you have to do that not by adjective, and we call it arguing by adjective, but by just simply laying out the facts,
Right.
right? And if somebody is really adamant about attacking us, using these ad hominem attacks, we will often drop a footnote at the beginning of the brief, and we'll set out in one footnote all of their attacks, all of their adjectives, smirching us and everything, and say this is what they've said about our arguments and about us and our integrity. We're not going to respond in kind. We will deal with the issues. So that is exposing them for what they're doing, and then, if, for instance, there's another problem with candor that's related to this. I think we have a high obligation of candor to the court to accurately portray what a statute says and means, what a case says and means. I think we have a high obligation of candor. There have been instances where somebody on the other side, and actually in one case, a judge, who would block quote something from a case, or in what the judge, a hearing transcript, and he would pull out and put ellipses, the 3 dots,
Mhm.
and pull out some words and leave 3 dots, okay? And when you go back and look at the quote, the case or the transcript, if you put those words back in there, it turned the meaning of the paragraph completely around,
Right.
180. Now, between you and me and the thousands, if not millions, listening to this podcast, that would be misrepresenting, wouldn't it? Okay, that would be an honest statement. Surely the person knew when they pulled those words out, that it reversed the meaning of the quote. But we would not say that. We are not going to say that, because as soon as you go down that road, it's a wrong road. So we would let the facts speak for themselves. We would say what we said about the transcript. We would say what he said about it, and then his quote to justify it with the ellipses, and then we would quote the section with the words back in there and say, when you put those words back in there, it means what we said.
Right.
Okay. So we would let the facts speak for themselves. And that's a proper way of doing it, I think.
Yeah. No, understandable. That makes sense. So far in your career, is there a case that stands out to you? Not necessarily because you won or lost it, or the weight of it, but something that kind of sticks out to you in your mind in your career so far?
There's 2, actually. One was a rather modest case, which I lost, and another one was a rather big case that I won.
Mm-hmm.
The modest case that I lost was early in my career, when I was taking pretty well anything and everything that I thought had merit. I represented a hotel owner who was sued by his former mistress for sexual harassment, who was an employee of the hotel. He didn't want to spend money on the lawsuit and wouldn't let me do things like depose certain people, because he didn't want to pay for it. Well, we get down to a jury trial, and he loses and gets a $500,000 verdict against him. He was unhappy. I was unhappy. It was a terrible outcome. And it convinced me never to take a case unless the client is prepared for me to do what is legally available and ethically appropriate to win. Because it's a complete waste to be involved in a case that you lose. It's a waste of my time, the client's money, the client's focus, his reputation, and everything else you can think of. And so if the case has merit, it's worth doing everything necessary to win.
Mm.
Now, the one that I won was the first case I argued in the U.S. Supreme Court, which challenged a judicial canon of campaign ethics, where it prohibited a candidate for judicial elected office from announcing his or her view on disputed legal and political issues. So it basically prohibited judicial candidates from saying anything other than their resume. It was so broad. I got that case accepted by the U.S. Supreme Court. And what made it so difficult is the object of your persuasion. Now I'm talking advocacy here. A book I read after law school because they don't teach you how to practice law, okay, and or be an advocate. And the object of your persuasion are the judges, right? And the judges that are there to decide your case. And in this case, there's 9 of them. And the best form of advocacy, as far as the argument to make, is one that would address their concerns, the concerns of the judge about your case. And then the best argument is one that addresses those. Well, I'm sitting here and thinking about judges who they themselves had been judicial candidates for office, like Sandra Day O'Connor. All right. And this was talking about judicial ethics, which is intensely important to them personally and professionally and affects them directly. How often do you how often do you argue to a judge something that they're actually hugely personally invested in, right? And so you had to make sure you understood what their concerns are and how important it was to address theirs specifically, understanding that this isn't like talking about some doctor's malpractice case. I mean, in this case, they're the doctor, okay?
Right.
And so that meant that by that time, 2002, I had a lot of associates, but I really dived into that case and wrote a lot of the briefing because I was really committed to a good outcome. The other thing it was completely novel. All right. They never considered the application of the First Amendment to the judicial canon of campaign ethics. Never. So it's completely uncharted waters. And as in many of my cases, you're talking about general principles, the First Amendment, and their application to a brand new situation. So that made it the hardest case I ever argued, but I did win 5-4.
Last question for you, and I posed this to Mr. Falk as well, but obviously there's been a lot of discourse lately about the rule of law in the legal profession. From your perspective, what does the rule of law mean to you?
Well, the simplest thing is it's a rule of law, not men. In other words, it's the juxtaposition of how should the law be established, in other words. Should it be established ahead of time through statutes and constitutions and rules that men are obligated to follow? Or should it be established on an ad hoc basis as you go along by whoever is in power? Those are the two models. And of course, historically, in the history of man, the second model has always been the case. The tribal leader, the king, the whoever the leader of was in charge of the particular body that we're talking about, from the family to the clan to the tribe to the race to the nation state, whatever. It was the whim of whoever's in charge. And it wasn't, there's been a few historical examples that have been very famous, historical examples of where they actually wrote down what the rules were going to be. And the king or whoever was obligated to follow it. And there have been several examples of that, starting probably with Moses, but as an example. But that's what we decided to go with, and it's the just way to go, because it gives you advance notice of what your conduct needs to be in order to comply with the law. You won't just be arbitrarily punished. They would have to show you violated this legal regime, this rule of conduct, and that protects you from prejudice and malice and arbitrariness, capriciousness, and which are all evils, and protects you from that, and makes us free. as a result, because it's only the rules have been set down that we have to follow, and we should follow. But everything else we're free to do. It's not like, how do we know whether we're free to do this until the king whacks us or not, right? It's a necessary precondition to freedom, which is the fundamental motivating principle of the founding of our country. So it flows from all that and is therefore critical.
Well, thank you so much, Mr. Bopp, for joining me and for answering my questions. It was a great conversation. I hope you enjoyed it too. But I so appreciate your time.
Well, thank you. Pleasure being on. I'm so privileged.
Thank you for listening to the Indiana Lawyer Podcast. To hear more from Bopp about his career, you can actually go back a few episodes in our podcast feed and find his conversation with fellow Lifetime Achievement honoree Ken Falk during this year's Leadership in Law event. And if you're not already subscribed to the Indiana Lawyer, we encourage you to do so. You can find more information on that on our website at theindianalawyer.com. Subscribers always have access to the latest legal news in Indiana and stories from our sibling publications, the Indianapolis Business Journal and Inside Indiana Business. You can also find the Indiana Lawyer on social media, Facebook, Instagram, and LinkedIn.
Get a behind-the-scenes look at Indiana's most influential leaders. On Business and Beyond, we go beyond titles and resumes to explore the personal stories, pivotal moments, and hard-won lessons that shape Hoosier leadership. Hear from the people driving Indiana forward in their own words. Subscribe and listen wherever you get your podcast or at ibjpodcasts.com.
Thanks for listening to this IBJ Media podcast. You're probably going to remember this ad. Do you know why? Podcast advertising works. 85% of listeners recalled hearing an ad during a podcast, and 70% of podcast listeners have acted after hearing an ad. So whether you're looking to be heard across the entire IBJ Media Podcast Network, sponsor one of our shows, or just start with a 30-second ad, IBJ Media can help. Contact advertise at ibj.com to learn more.